This case forces the court to answer one of the hardest questions in criminal law. When is a mistake just a mistake, and when does it cross into criminal negligence? Kayla Roack stands accused of abandoning her child, an allegation that instantly raises emotional alarms. But what makes this hearing intense isn't just the charge, it's the tension between rehabilitation and punishment. We'll hear glowing testimony from Child Protective Services, sharp opposition from the state, and a judge who refuses to be swayed by tears alone. As facts collide with emotion, one decision will determine whether this mother walks out on probation or faces prison time. Stay with us, because every answer in this courtroom leads to another question.
All right, court is calling. And I need everyone in the box. If you're behind the court reporter, please do not speak because she needs to be able to hear. Court is calling 2022 CR 9351, State of Texas versus Kayla Roack. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
For the defense?
Albert Rodriguez.
And are you Kayla Roack?
Yes.
According to the plea bargain agreement.
Right here, the judge lays out the legal foundation of the case. Kayla has pled to a lesser-included offense, abandonment of a child with intent to return, with a 2-year state jail sentence and a $1,500 fine attached. That matters because this isn't a dismissal or a slap on the wrist. It's still a serious felony-level charge. The state opposing probation immediately signals concern beyond just this incident, especially when multiple cases are being considered. The PSI report becomes critical here because judges rely heavily on it to evaluate risk, credibility, and future behavior. Everything that follows is about whether Kayla has earned trust or exhausted it.
In this case, you pled to the lesser included offense of abandonment of a child with intent to return. Punishments to be assessed at 2 years in the state jail facility. There's a $1,500 fine. The state is opposed to your application, and they're taking several cases into consideration. Have both parties had a chance to review the PSI report?
Yes,
State?
Your Honor.
Your Honor, I don't know if yes, Your Honor.
All right, any objections to the PSI report, defense?
Other than it says that she's unemployed, she is employed.
Okay, any other objections than that?
No, Your Honor.
All right, state, any objections to the PSI?
This moment might sound minor, but it's legally significant. The defense corrects the PSI report regarding employment status, and while that may seem small, accuracy in a PSI is everything. Judges use this document to assess stability, responsibility, and honesty. Even small errors can undermine confidence if they suggest minimization or inconsistency. The fact that neither side raises further objections helps Kayla here. It suggests no hidden red flags beyond what's already disclosed. In probation cases, credibility is currency, and this exchange quietly sets the tone for how seriously the court will take her progress.
PSI report?
No, Your Honor.
All right, state, you are opposed to the application? Do you have any witnesses?
We do not, Your Honor.
Defense, do you have any witnesses?
Yes, Your Honor.
All right, defense, you may call your first witness.
Is that okay?
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, I'm gonna need you to speak up.
Okay.
All right. Could you state your name for the record?
Cynthia Cisneros.
All right, and could you spell it for the court reporter, please?
CYNTHIA, last name Cisneros, CISNEROS.
All right, so we're back on the record in 2022 CR 9351, State of Texas versus Kayla Roack. And you're still under oath. And could you restate your name, please?
Yes, Cynthia Cisneros.
All right, and standing in for the state?
Ruben Herrera for the state, Your Honor.
All right, counsel, you may proceed.
You stated your name. What is your profession, occupation?
Yes, I'm a family-based safety services worker for Child Protective Services.
And have you supervised or participated with Miss Kayla?
Yes, sir. I have been her worker since September of 2022, and her case just recently closed here in February.
Okay, and can you tell the court how you have interacted with Miss Kayla and how she progressed?
Sure. So,
This testimony is powerful. A CPS family-based safety services worker doesn't just check boxes, she monitors real-world behavior. Hearing that Kayla complied with parenting classes, domestic violence services, and drug testing with all negative results directly supports the defense's argument for supervision over incarceration. Protective daycare, stable housing, and consistent compliance all point toward rehabilitation, not neglect. From a legal standpoint, this is the strongest evidence Kayla has. Judges don't just look at what happened, they look at what changed afterward. And here, the change is documented.
Part of my job is to obviously, go into the home, make sure, things are going well with her and her daughter, also to comply with services. So specifically, we had enrolled Kayla Rolag into parenting, domestic violence, and random drug screenings. She excelled the whole time. She also got protective daycare for her child. So that's where she currently is during the day. And then she does reside with maternal grandmother and Kayla during the day. But she did really, really well. All drug screens came back negative for all substances. She was compliant in all of her services, received positive feedback from all her providers. And my time in working with Ms. Rolag, I really did not experience any negative feedback, any negative experiences or anything like that.
All right. And are you fully satisfied that she has participated well then?
Yes, definitely.
As a witness?
Mrs. Narrows, does the defendant have a support system in order to help her care for the victim in this case?
Yes.
And nothing further witness, Your Honor.
All right. So how long did you supervise her?
Oh, since September of 2022.
And
And
how
so-
often were you seeing her?
I was seeing her about twice a month.
All right. And when's the last time she had a drug test?
February of this year.
Okay. All right. Thank you.
Thank you.
Your Honor, if I may, Ms. Kayla would like the court.
State, have you reviewed the documentations he wants to present to the court?
I have no objection to the present state's or the defense documents.
May I approach?
Yes. And for the record, the court is reviewing certificates that have been offered on behalf of Ms. Rolick by her attorney. Any other witnesses?
No witnesses, Your Honor.
All right, State, you're opposed to the application?
We are, Your Honor.
All right, you can make your argument, State.
Your Honor, although it's been presented that the defendant seems to be taking some steps in
All right, you all need to whisper in the box.
taking responsibility for this matter. Based on the allegations, Your Honor, it shows a gross negligence and the lack of proper judgment. In fact, that the defendant did admit to leaving her child purposefully at the home without checking to see if there was anybody there to supervise the child, Your Honor. This resulted in the victim child being able to escape the residence on her own, being outside in cold temperatures with nothing but a diaper on. Based on the allegations, Your Honor, the state would oppose the defendant's application.
This is where the courtroom temperature spikes. The state reframes the incident as gross negligence, emphasizing the danger. A 2-year-old outside in cold weather wearing only a diaper. The judge's response to Kayla's tears is blunt and intentional. Courts don't sentence emotions, they sentence conduct. This exchange reminds everyone that remorse must be paired with accountability. Tears may be human, but facts are legal. And right now, the court is weighing whether this behavior crosses the line from tragic mistake to unacceptable risk.
All right, is there a reason for the tears? Because what he's just saying is true.
No.
Now, I know people want to cry before the court because they want the court to be lenient, but let me just tell you, tears don't sway the court. I'm just here to listen to facts to see if you've done anything that would justify the court placing you on probation. Okay? All right, so that's why you're asking for her to go to prison?
Yes, Your Honor.
All right. And have you State, have you had a chance to review her certificates?
I did, Your Honor.
All right. All right, defense.
Yes, Your Honor. And Your Honor, we're asking that the court consider supervision for her. This offense, first of all, the child just wandered away from in contrast to what counsel says that the child escaped. So it wasn't a matter of escaping. She was just wandered off as children off too. My client had stated, she told the police that she thought that the adults were inside the home and that the child was being taken care of. And it was just a mistake on her part. And I would like for Ms. Rolak to address the court on this issue of abandoning the child.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Kayla Roloff.
All right, defense.
And why do you, first of all, was this an honest mistake on your part in leaving the child?
Yes, I would never.
Kayla's testimony is emotionally raw, but the judge isn't focused on feelings. She's focused on logic. The court zeroes in on one critical issue. How does a child end up alone if supervision truly existed? The PSI report complicates things further, suggesting blame may have been shifted to others. In probation hearings, ownership matters more than explanation. When responsibility is fully accepted, judges are more willing to offer second chances. This moment becomes a credibility crossroads because explanations that sound reasonable emotionally can still fail legally. Do you believe this was an honest mistake or preventable negligence?
I never want to leave my child on purpose. I take care of her every day. I'm the only person that she's been with every day of her life. I love her and I didn't mean to put her in any harm's way.
All right, somebody want to explain to me, the crux of this entire situation is some kind of way, a 2-year-old in a diaper ended up wandering the streets in a diaper only in November, and it was cold. So, I mean, that's what we need to get to the point of, because in the PSI report, she's blaming the people who CPS has put in charge of helping her supervise the child. That's who she's blaming for her child being out and about, because in the PSI report, it states that guilt was minimized. And in the PSI report, she's stating she thought these other people who CPS put in charge of her child as the person to chaperone or supervise, she's blaming them, saying that they were supposed to be there. So somebody explain to me how a 2-year-old gets out of a apartment or residence that's supposedly locked or should have been locked.
So she was naked, not wearing any clothes, because that's how we sleep. She still goes and runs around naked. We just got out of diapers, so she usually just wears a underwear. But that's why she was naked, not having any clothes. And I do not blame anyone else. This is my fault. I should have been the one to check if anyone was there. I was just saying that I had thought, because when I had laid down my daughter, my mom and my uncle were still there. So that's the reason why I didn't check. But this is my fault. I am taking full responsibility.
Okay, I hope everybody understands. I'm always curious. I have questions. It sounds odd to me, unless people are living in a mansion and you have the West Wing and the East Wing and people leave and people don't know it. So I'm just finding it, or I just have questions. How a child gets left, and I don't even understand how children get left in the car by themselves, but in a home, how does a child get left in a home by themselves if a parent is leaving and other people are there and other people see you leave? Nobody thinks, oh, we can't leave because there's a 2-year-old here. How does that work?
So when I laid down my daughter, my mom and I both went into our rooms. That's why I thought that she was there. So I didn't hear no door open or close, and I hadn't come out of, so I didn't see anybody. I figured my mom was still home because I didn't see anybody out there.
So you don't see anybody and you just leave your daughter in.
The state's questions are short, simple, and devastating. No knocking, no confirmation, no visual check. These aren't trick questions. They're about basic parental responsibility. In court, what didn't happen often matters more than what did. This exchange strips the situation down to its core. Assumptions were made where certainty was required. From a legal perspective, this is the exact type of conduct probation is meant to prevent. The court now has to decide whether supervision can realistically stop this from happening again.
in a house and you haven't seen anyone?
Just because I thought that my mom was in her room still.
Defense, you may continue.
I have no further questions, Your Honor.
Any questions?
Just briefly, Ms. Rolak, how far away is your mother's room from your room?
It was like down low.
Did you knock at all to check if she was still there?
I don't think so.
Did you walk around the apartment to confirm that there was any adults present before you left the apartment?
I just walked through the living room.
Nothing further else.
All right. Any other witness defense?
No, Your Honor.
All right, I want a UA today, then I'll make my decision. All right, we're back on the record in 2022 CR 9351 Kayla Rolag. And the court asked the defendant to do a UA. And I'm very happy to say that the UA.
This is a pivotal shift. The negative UA immediately strengthens Kayla's position. Courts view sobriety as a foundational requirement for probation success, especially in child-related cases. Combined with completed services and CPS compliance, this result provides the judge with something tangible, proof, not promises. Still, probation isn't automatic. The judge now weighs structure, monitoring, and long-term accountability. This is the moment where incarceration stops being the default and supervision becomes possible.
Was negative. All right, is there anything else from either side with regards to argument?
Nothing from the state, Your Honor.
Anything else from the defense?
Well, no, I have a request, but
What is your request?
she's been on the monitor for 5 months. We're asking if it can be removed.
Oh, she's going to remain on the monitor. All right. So, Ms. Rolek, I wanted to tell you, and this is why I always keep an open mind on everything, just reading your history and looking at everything, someone would suggest that you should go to prison. But, I always tell people whether you think a judge is going to do something or not. And I would always tell my clients, hey, you know what? We have to give the judge something to suggest you're not going to prison. So don't come in and throw yourself on the mercy of the court and you have done nothing. You understand? So I see that you've done a lot. I see that you completed everything with Child Protective Services. And sometimes Child Protective Services, they're always overworked and underpaid, but you actually had a good caseworker to stay on top of you and make sure that you were doing everything that you were supposed to be doing. And I see that during this time, you got.
This is judicial philosophy in action. The judge explains that probation is earned, not begged for. Education, compliance, and stability all factor into her decision. Conditions like living arrangements, no adult males in the home, monitoring, and regular field visits aren't punishments, they're safeguards. This isn't leniency, it's controlled opportunity. The court is designing a structure that prioritizes the child's safety while giving the defendant a chance to rebuild responsibly.
Got your GED, you're enrolled in college, that's great. And to all the children who are out there who always think that the best college to go to is someplace that's not at home. Sometimes, the best college is a college that's actually in your city. People always want to go to some other college because they think it's the best college. And I always say the best college is wherever you are if you make it that best college. So I see that you've done that. You have supervision because you're not living by yourself. I'm going to want you to continue to not live by yourself. Now, once you've been on probation for a while, your attorney can always come back and ask the court to reconsider that part. So who are the persons you're living with?
I live with my mom.
Okay.
And my daughter.
And what's your mom's name?
Brenda Marshall.
I'm sorry?
Brenda Marshall.
Brenda Marshall. And I'm assuming your mom wants you to remain with her. All right. So this is what the court is going to do. The court is going to grant your application, and I'm actually going to give you deferred adjudication. So 4 years deferred adjudication. There's to be a $1,500 fine that will be probated. Taking consideration County Court Cause number 688-620, 691-438, Night Mag number 675530, proof of employment within 30 days. And in this court, if you're on probation here, I don't allow you to be a home health care provider. So there's to be no employment as a home healthcare provider with minors, 250 hours community service restitution. Those hours to be waived if you provide proof of enrollment in college, which you have. You need to provide that proof to probation today. And for the court to give you credit for that, you need to take at least 9 hours a semester. And I don't allow people to do that thing where they say, oh, here's my 9 hours for semester, and then they drop classes. That's expensive.
Can I say something?
Yes.
I actually am going for a pre-major in psychology, and then I want to go to UTSA. So after these, I'm going to do I think around 17 hours a semester because I'm.
Thank you. See, when I tell people that every semester I would do 24 hours a semester, people don't believe it, but it can be done.
Yeah.
All right. So provide proof of enrollment in college with at least 9 hours. Probation, I'm going to ask for parenting classes. She's already completed those. So you'll need to provide documentation to that. She is to reside with Brenda Marshall. And so it's only you two in the household, right? All right. There to be no adult males in the household residing there.
Okay.
If something changes, you can let me know. I just found from my experience as a defense attorney on CPS side, what ends up happening is mothers are doing great. And I've had male clients over there too. They're doing great. Then the next thing you know, they end up getting a new partner. They don't vet that partner appropriate, and everything that goes downhill. So that's why I'm putting no adult males. So she's not allowed to reside with any adult males. Probation, I'm going to want field visits once per month, regular reporting, and the field visit can count as her reporting. And that field visit is until further notice, and we'll do regular UAs. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
If I know you said I could take my certificate that I already did parenting class.
Yes.
Can I still take another one? Because this last one that I took with the San Antonio Fatherhood Campaign, I actually learned a lot. And if I could just keep learning because my daughter is getting older.
Okay.
And also, is there any way that I can get that y'all can help me with therapy or getting into counseling?
All right. So what I'll do is probation, we'll add parenting classes. And make sure you notate in that the parenting classes were at Ms. Roleg's request. And also, do we need a mental health caseload or mental health evaluation probation?
What's your mental health evaluation for a referral just to sit in on?
All right, we'll do a mental health evaluation for referral.
I did do that, and she said that I didn't have any things, but I have a lot of anxiety, and I just deal with a lot of stress and stuff. So that's why I asked for the therapy or counseling.
All right, they'll take care of it. They're going to make it happen. If it doesn't happen, let me know.
Okay.
I'm here. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea.
This case ends with deferred adjudication, 4 years of probation instead of prison. That means Kayla avoids a final felony conviction only if she follows every condition imposed by the court. Monitoring, education requirements, parenting classes, mental health evaluation, and strict supervision make it clear. This second chance comes with zero margin for error. The judge balanced accountability with rehabilitation, sending a powerful message. Mistakes involving children will be scrutinized, but change backed by action matters. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right? All right, good luck to you. Good job.
Thank you so much.
Oh.
Thank you so much.
Oh, you're welcome.
Your Honor,
Yes.
did you specify?
Wait, am I still on house arrest?
Oh. With regards to the monitor probation,
Yes, Your Honor.
let's keep her on the monitor for 2 months. If there are no issues, then it can be removed.
GPS partial.
Yes.
I can like take my daughter to the park and stuff.
Yes, it's probation. Just make it tracking,
Thank
but
you
you'll
so
still
much.
need to let probation know where you're going to be, okay?
Okay, thank you so much.
You're welcome. And this is, the top copy is for the state.